The grounds for divorce in New York are as follows. The most common is the marriage has been broken irretrievably for 6 months or more. And why do I say that's the most common? Judges don't want to hear why you're getting divorced because frankly, it doesn't matter. The others involve adultery, cruel and inhuman treatment, or sexual abandonment, and there's a couple of others that are never used. When you have a client that wants to proceed for grounds for divorce and try to show that there's been cruel and inhuman treatment, the courts don't care because it doesn't make a difference as to the financial division in the case. Rarely will those causes of action or those claims be relevant, and it's only towards a possible custody fight if those actions directly affect the custodial relationship, such as with the case with domestic violence. But 99 times out of 100, you're going with irretrievably broken for 6 months or more. Assets are divided typically equally, especially in the case of a long-term marriage. If you have a marriage that's been there for a blink of an eye, like 6 months or a couple of years, generally people are going to try to walk away with what they have. Other than that, what was accumulated during the marriage will typically be equally divided. And that includes many things. Acquisition of property, retirement assets, 401k contributions, time in a pension. Those are typically divided equally for what was accumulated during the marriage. What is alimony? In New York, we call alimony maintenance. In fact, in many states, it's called maintenance. And here's why. It's designed to maintain the party earning less money to a point where he or she can become self-sustaining. In New York, it's a specific formula based on the income of both parties and the length of time they've been married. If there's children, the amount being paid for maintenance will then be calculated into the amount for child support as well. Is it typically awarded? It typically is if the parties fall into that formula. The question becomes, will it go over the cap in New York, which is currently set at $228,000 for the person paying support? Then the court will look at such things as lifestyle. Did they live a very extravagant lifestyle? Does the party earn way over the cap? Were they flying around the world? Did they go to private schools? Those kind of things. When people talk about custody, primarily they think they're talking about where the child is going to live. That's a matter of residence, residential custody. When we as attorneys and courts talk about custody, we're talking about who makes the decisions in 3 major areas: healthcare decisions, educational decisions, and religion. Most parties, they agree on those things. Is somebody going to really deny needed healthcare to the child because of a dispute? So healthcare, education, religion, usually the parties can agree. The problem happens is when they don't agree. Then parties typically pick one party to make a final decision after they have a free and open discussion, both with the experts in the field, meaning the teachers, the doctors. Only if they can't make a decision, one party will make a decision, and if they can't agree on that, they go to a court. As far as residential custody, that's a little bit more simple. Where's the party going to live primarily? Where they're going to go to school? Who's going to pay child support? And that's really where the dispute arises. People will fight over residential custody because some people want that for child support purposes or to avoid child support purposes. In fact, people will insist on 50-50 custody because there's a misconception that if there is 50-50 custody, one party's not going to pay support. And in most cases, that's just not true. If you're in New York and you have any questions about these topics, contact us at the Sklavos Law Group.